Introduction. Under the scope of injunction, it can be explained that it is a type of remedies granted by the court to those the claim is made against them, so as to restrain or require them to do the specified act. In Malaysia, the legislation governing the power to grant the injunctions are the Courts of Judication Act 1964 and Specific Relief Act 1950. There are few types of injunctions, however. In this context, the discussion will focus on the interlocutory or interim injunction. Concept of interlocutory injunction. In general, it is a court order to someone whom it is directed to do something or not to do something for a specified period of time, or until new order from the court, and can be given at any time as long as in period of the suit. The reason why this remedy is given by the court is to aid the affected party in terms of action as the compensation given or damages were to be inadequate. The inadequacy of damages can be a determining factor for someone to opt for injunctions. However, it only applies when the damages or the monetary compensation could not cater the loss suffered by the plaintiff. One such condition is the violation against a person's right, and that person suffers injury in terms of his reputation, in which cannot be solved through damages. It is also can be considered as irreparable harm. Hence, this academic writing will explore on the origin of the interlocutory injunction through the landmark case of American CYNAMID Co. against Ethican Limited, and subsequently demonstrate a detailed explanation of the case law in terms of the test set out by the judges together with the principles underlying in order to understand thoroughly. It is indeed necessary to include the discussion on the application of the principles into the local case.
The fact in this case is that this case is concerned with interlocutory injunction. The American CYNAMID, who is the appellant, is an American company who owned a patent for artificial absorbable surgical sutures. The respondent, who is Ethican Limited, was a dominant supplier of catgut in the UK. The respondent were proposing to introduce their own artificial sutures, which is known as XLG. However, CYNAMID contended that XLG infringed their patent and stated a quia timid action against Ethican to restrain the threatened infringement of their patent from supplying the sutures of XLG to surgeons in the UK. The issue in this case is whether the use of XLG as an absorbable sutures infringement of CYNAMID patent. For the judgment in this case, the court allowed the appeal where it stated that in the case regarding a patent, the court must determine the matter on a balance of convenience. It is satisfied that the case was on trial and no other evidence being brought to the court. Thus, the appellant would be entitled to a permanent injunction. The court also should consider whether the damages were adequate for appellant if injunction was not granted. The court also must satisfy that the claim is not frivolous. The balance of convenience was established and the appeal was allowed. As all the principles and tests have been proven, the appellant was granted an injunction.
Assalamualaikum, my name is Alma Zahira binti Abdul Ghani and I will be explaining on the part of the test that has been established under the case of American CYNAMID Company against Ethical Limited. So there has been three tests that has been established under this case. And the first one is whether if there is a serious question to be tried. The second one is whether the damages can constitute as adequate remedy if the injunction is not granted. And the third one is whether the balance of convenience favors the award of the injunction. And then moving on to my next. Okay, on this slide I will be explaining further on each of the tests that has been established under the case. The first test is whether if there is a serious question to be tried. So the court has stated that the question in trial must not be vexatious or frivolous, and that the materials involved must prove and disclose that the plaintiff has a high chance to succeed in securing a permanent decision. If there is a failure, then the application shall not be granted. It shall be rejected. And similarly, if there is no valid cause of action brought by the plaintiff, the application shall also be denied. And then the second test is whether the damages can constitute as adequate remedy if the injunction is not granted. So there are two steps to be considered, which means that the court will look into both parts of the parties, on the part of plaintiff and also on the part of the defendant. So on the part of the plaintiff, if the defendant will be able to give an adequate financial favor to the plaintiff, and that will lead to the court not granting an interim injunction. Whereas on the part of the defendant, the court will grant an injunction if the defendant will be compensated adequately. So The third and last test is whether the balance of convenience favors the award of the injunction. So, the balance of convenience shall arise when appears to be doubts regarding the adequacy of damages to the claimant and also to the defendant. So, the court will look into three considerations to be looked upon, which are the preservation of the status quo, the strength of the case in relation to the opponent, and also other special factors. Thank you.
Assalamualaikum and hi, my name is Anis Kemilia binti Usaimi. My metric number is 265137. So I'll be moving on to the next slide, which is principles under American CYNAMID. So under this principle, the most important elements that the court will be taken into consideration is the balance of convenience. There are three considerations that may vary from case to case as the factors which may be relevant in determining the balance of convenience. The three considerations are the preservation of status quo, the strength of case in relation to the opponent, and the last one is other special factors. So for the first factor, which is the prevention of status quo, this factor will be taken into measures if the defendant adjured to do something which he never done before. This factor had been applied in the Malaysian case, which the case of Syarikat Tunggaring Kilang Papan Sendian Berhad against Sabah Forest Industry Sendian Berhad, where the court held that the interim injunction order to be dismissed, as the court said that it will be undesirable to maintain the status quo until the trial. The next factor is the strength of case in relation to the opponent. So this factor will be relevant in the case that the fact of the case may be deduced from the evidence that been adduced by one party is not subject to credible dispute. This factor have been applied in the case of Intel Corporation against Intercard System Sendian Berhad. So the High Court granted an interim injunction against the defendant from using the name Intercard, while affording protection to the plaintiff, who is the owner of the Intel trademark. Last but not least, the third factor, which is other special factors. So this factor have been stated specifically in the case of American CYNAMID. So the fact is the plaintiff sought for interlocutory injunction to stop infringement of its patent when the defendant intended to launch a surgical suture in British market. On appeal, the House of Lords held that there was a serious question to be tried, and agreed that the balance of convenience favored the grant of injunction in which the product were yet to be marketed. Thank you.
Hi, I'm Dalila Zano Abidin and my metric number is 264505. So today I'll be talking about the application of the principles in the local cases. So as we can see in the first case, Siva Perumanan against Siak Yong, relatives Berhad, whereby the defendant applied for interlocutory injunction to take back the quarters due to action of the plaintiff. So to apply to this case, regarding the principles, the respondent has failed to show the decision by the industry court regarding the appellant's job, and there is no specific factual evidence to suggest a real possibility of success at the tribunal, and also there is no interlocutory junction because the remedy is adequate and the balance of convenience is falls on the appellant. Lastly, in the defamation case in Mohammed Zainuddin bin Putih against Siap Ji Seng, the court held that interlocutory injunction to be set aside and the motion is dismissed. Hashim Yok, a Sani judge, stated that there was a notice of motion requesting an order to set aside the interlocutory injunction. So this is because the plaintiff did not reveal the full facts accurately to the court and did not disclose the material fact to the court. So it must be noted that a party who seek for interlocutory must disclose all the material facts and it must fully disclose because nature of court to be satisfied that he has a good faith and he does not have intention to deceive the court. So the court rejected the argument in American CYNAMID because there is a significant issue to be tried on and the action could therefore be taken to avoid the status quo. Thank you. Next, in Wahlun, Jelapang Tin Mines Sendian Berhad against Chiang Yang York, whereby in this case the plaintiff seek for an injunction to prohibit the defendant from entering on the land. So in order to apply for interlocutory injunction, the plaintiff need to prove that the damage is inadequate. So in this case, Abdul Qadir Judge stated that no interlocutory proceeding can be granted if the damages is an adequate remedy upon the granting the interlocutory injunction. And he also stated that the court must look at the whole case for both strength of the claim and defense, then only the court can decide what is best to be done. So in this case, the court refused to grant the interlocutory injunction to the plaintiff.
In conclusion, the discussion above has given a clear view on the basis of how interlocutory injunction actually works. The existence of this remedy is very essential for those entitled. Hence, the existence of the interlocutory injunctions has fulfilled the element which subsequently proved that both law and equity work side by side and complement one another. Thank you.